in establishing the common law court of record, do you also have to establish your capacity as a man? I've got somebody attempting to trespass on my property, and they are also attempting to diminish my capacity as a man by alleging that I am either a natural person or a corporation.
That's wonderful. Who cares what he believes? You got to convince the jury. You don't got to convince anybody. You got to convince yourself, God, and the jury. That's it. Okay. I don't give a rat's behind what anybody believes. If I believe in the Tooth Fairy and Santa Claus, if I believe I have to pay taxes, or that's my belief. I just got to hope there's a crazy 12 people on a jury that have the same crazy beliefs I do.
Well, we're working on converting them all, right?
That's why it's kind of dangerous sometimes, because you don't know those 12 random people out in society believe your crazy beliefs. So sometimes it's great to go for the man in the black and white robe, because your word has just as much standing as the other person's word in that courtroom. And the man in the black robe or the woman understands that, and the scales of justice have not been tipped one iota yet at this point. So until somebody comes forth with a contract, it's a draw. There's really nothing the man in the black robe can do. But with a jury, the jury's fun. They could take 50-50 and they could turn it 99-1. They could do all kinds of magic with your claim or his claim. And you could say, holy cow, how did they come up with such a crazy, that's what they believe. In that society, because, I didn't realize I packed the jury with 12 Muslims. I forgot that they're doing Sharia law. Oh, my God. I just got slaughtered. It's like, right, did you know what these people believed in before you let them judge you? So sometimes it's good to let the man or the woman in a black robe decide the matter, because it has to be expressly written into the contract. If your name is not expressly within that code or within that act, how could they hold you accountable to perform unless somehow the other side could prove that you are bound by those rules? Good luck.
Or you consented.
Right, because they said I consented. Well, look at this. Did you seen me sign that? You know for a fact that's my signature. Were you witnessing to that? No. Good. You know what? I'm going to get you to file a false claim, Jim. Not Mr. U.S. Attorney. I'm going to get you, Jim. I'm not going after the Department of Justice, Jim. I'm going after you, Jim.
And I also wanted to thank you, Karl, for putting that Richard Cornforth info out there. It's I listened to the episodes that he had on there, and it was like a light bulb went off.
Right. It said it was funny.
Oh, it's great videos.
Like I said, that Dallas Debt guy, him and his buddy, his sidekick on that show, were bashing me during the summertime about that silly nonsense. Now, almost every other word out of his mouth comes Trinzi versus Pagliaro. They said, holy crap, Karl was right.
Well, the four legs under the table makes perfect sense now.
There you go. It's a beautiful thing, man. I'm glad somebody else. I'm not an original thinker. I'm just grabbing it like some Richard Cornsforth, Clayton Cherry. I grab it from Winston Shroud. I grab it from Erwin Schiff and Leroy Schweitzer, and I grab it from everybody. Adam Smith. Locke. Kant. I grab it from everybody who's lived before us, and I just try to smash it into a little one sentence thing. Like,
I appreciate you getting out there on your own call and giving us all the time that we've asked for, and thanks for all the effort you put out there, Karl. I appreciate it.
And Greg is a good guy too, man. He helps me a lot on these calls because, like I said, usually my head is pounding this time of night.
Well, and Greg, I really enjoyed listening to him talk about definitions again, because I've learned a lot about the words that we use, and if you assume that they apply to you, well, then they apply to you. But
you're going to find out. What's your name?
This is Highballing. This is Dallas from Texas.
Oh, hey, Dallas. If you really want to understand the mastery of the words, this is what I did, because I was getting clobbered in court. So I wrote a dictionary, and that's my thing. So when I'm not going to correct you from saying assumption to presumption, because it's a huge difference in assumption and but it is all mastery of the language. If you know when you're going into a common law jury, you want to speak they speak. You want to speak if you realize a whole bunch of Spanish people or Mexicans or black people or white people or rich people or poor people, you want to speak their language. And they will not bicker with you the difference between an assumption and a presumption. One is going to cost you money, and one is just an error. There's a difference between lifting something up and being held liable. That's assumption, and presumption means, well, I just made a boo-boo. Not going to cost me nothing, though. So like I said, judges are listening for these magic words. So if you say something wrong, you better, if you don't think you got a mastery of the language to go before a black-robed one, you better go for a jury if you feel more comfortable with them, because they'll allow a lot of mistakes. A lot of mistakes in your pleading, your writings, all kinds of stuff. They'll accept a lot of errors. But a black-robed one, if he wants to get you, he's just waiting for you to say one little thing wrong. It's like when you said assumptions. Good. He's denied. You're like, what? Oh, don't worry about it. Thank God I'm out of this one. The judge, black-robed one, will say, oh, thank God he said assumption instead of presumption. Wow, I'm done. Thank the Lord, sweet Jesus. This guy almost had me. That's why I try to tell you folks, if you want to go in front of a black-robed one and you think that he's going to look and ambush you, figure out a way to get it down to him in one sentence. And stay with that one sentence and don't wiggle, don't move, don't blink. Because he's trying to get you to say a word where you say, wow, I was able to protect all my buddies at the Bar Association. I was able to protect the state. Oh, my God, this guy really had me scared there for a minute because this one-sentence claim I couldn't do anything with. There was no way out. He said assumption. It's like, oh, you make an assumption. Yes. Oh, thank God he made an assumption. We're out of here. Because you said, case, dismissed, denied, have a nice day. Like, what? What did I do? What did I say? He's not going to tell you. So next time you need competent counsel, go hire one. And you just missed it by one word. So like I said, that's why I say to you folks, be really careful and make your claims extremely short. 1-2 sentences, make your compensation maybe 1 sentence, 2 sentences long, and get out of there. And keep your mouth shut and just let the paperwork ride. Don't explain your paperwork to the black-robed one. Explain it to the jury. They'll forgive you. The guy in a black robe's not going to forgive you. If he doesn't want to. If he doesn't want to. But then you opened your mouth. And you allowed him to make the judgment call. Like, oh boy. He's going to jump all over you. If he chooses to. Maybe he likes you. Maybe he doesn't. You know what I'm saying? I don't want to trust, some guy in a black robe. When it's between me and the state, I honestly, I'd rather take my, chances just with my words that I write down on paper and just let the paper ride. So just look, I placed my bet. I'm just going to let it ride. You want to explain your bet? Nope. You want to describe what kind of card you have in your hand? Nope. I'm all in. Just let it ride. And
well,
there you go.
Karl, if you're going in as a prosecutor, you're not the one that's going to be asking for a jury, right?
Oh, of course. If you're the prosecutor, you're going to be asking for a jury when the other side answers. If the other side doesn't answer, you're just going to get the marshal or the sheriff's department. You're going to drag that guy in. You're going to have him read the charges or read the bill in open court. There's going to be somebody from the court clerk's office, and they're going to witness that you presented your claim to this man in open court, and he shut his mouth, didn't say nothing. He refused to answer through the mail. He refused to answer in open court. It's done for all time. He can't come back and void that judgment because it didn't come by way of oath of affirmation in open court. It is recorded, it's pressed upon the record, and it's etched in stone. He can't come back and modify, alter it, or ask for a retrial because he had his day in court and he kept his mouth shut. It's done. But if he doesn't appear in court, if you just get a default or summary judgment against him, he can come back, his children can come back, his great-great-great-grandchildren can come back and reclaim his what he lost based upon a default judgment. So default is a simple.
That's something that I learned from Richard Cornforth was the void judgment. If there's no verified complaint or any witnesses or anything, then you can actually turn that judgment back.
Right.
There's tons of case law now.
Right. Well, you don't need a lot of case law. He didn't say this, but I did a lot of research myself, and it's the Judiciary Act of 1791, Clause 31, which simply says it doesn't matter if the man dies in the middle of a hearing or a trial or a claim, his great-great-grandchildren can pick it up when they find the claim laying somewhere. And they could come and move a court, and they could prosecute the claim on behalf of the great-great-great-great-grandfather. So you don't have to use a lot of precedent. It's well established in law. You don't have to never use precedent. Never. You can use precedent as an exhibit, attach it to your claim, but never, ever put it in your claim.
Oh, okay. That's all right. Cool.
Yeah, it's not your words. It's somebody's opinion from 1776. It's not your. You didn't write the damn thing. You have no idea what he wrote. Like, I'm tired of these people say, well, let's reinterpret the Constitution and Second Amendment. You see that comma there, a semicolon, a colon? See, this is what Thomas Jefferson meant. No, look, you know what? I don't give a rat's ass what he meant. You know what? Somebody going to make a claim that by me carrying a gun is causing them harm? Well, no. Well, yes, it is. It's hurting my feelings. Okay, show me the bill where you had to go to a psychiatrist and you had to pay for a psychiatric therapy because of my carrying a handgun. Well, I don't have that. Well, then you don't have a claim. Leave me alone. And if you don't bring that claim forward, that's what I'm going to sue you, and I'm going to say you made a false claim, and now I'm coming after you for saying that by me carrying a gun caused you harm. And you can't prove that claim, now I'm going to make a claim that you're filing a false claim and besmirching my good name and interfering with my rights. Not rights established by the Constitution, or rights because you believe that you could carry a bazooka on top of your head while singing Yankee Doodle Dandy on one foot. You could do whatever the hell you want. Not because some document says you could do it, because you say you could do it. Go ahead, Greg.
One of the reasons that lawyers always use precedent cases and citations is they are incapable of filing a claim when they're operating in the capacity of an attorney. They can only petition the court to request permission for them to give an order that they would otherwise be unable to get done. If they were showing up as a man, they could just make a claim. But because they can't actually claim the facts and law of a particular situation, they then go, well, here we have this circumstance in this little case here. And now if we go back to 1492, we see Columbus, and the boys ate their cabin boy. And then we come forward to, 1924, and we see that, the Rothschilds decided to crash the stock market and ate their cabin boy. And then we came over to, 1965, and we found that LBJ went out on his yacht and they ate their cabin boy. So we can find all these legal precedents to show that it's totally righteous and okay for you to eat your cabin boy. All right? And so now they're going to say, in light of the fact that all these other cases have been ruled that it was okay to eat a cabin boy, we petitioned the court, we begged the court, we moved the court to judge in our favor based on all that. In other words, they can't prove that it was all right for you to eat your cabin boy. So what do they do instead? They go and they find all the other people that ate their cabin boy so that they can say, okay, please give us permission to do this because we can't prove it. All right? And so all you're doing when you're trying to be a good lawyer and copy their strategy is you are copying their deficiency. All right? And you're falling into, they actually are operating from a position of deficiency, which is why they have to work so hard and they have to come up with so much stuff and they have to come up with so much research and they have to do all this stuff and have to be able to spin 16 plates on little sticks at the same time while whistling Yankee Doodle. They have to because they're not there as a man making a claim.
They're in a diminished capacity.
They're in a diminished capacity, so they've got to go and come up with all this proof in order to get granted permission from the magistrate to say, okay, I guess that's so. But it still isn't proof.
I love it. Right? Thank you.
But you don't have to do that. But in the meantime, please don't eat your cabin boy.
I'm trying to quit.
Yeah, and that's the story of the Maginette. If you want to read that, that's where common law basically got all its precedent established in 54, 74.
Great information. So just to throw something out there, if someone wants to take me to court and the attorney is the only one that shows up, he's got no verified claim. He's got no witnesses with firsthand knowledge. The next thing should be motion to dismiss for what?
Nope, you got to make sure you're in common law. I'm telling you, John.
Okay.
I'm telling you.
So before you even go, your first response to a notice before suit is filed from whatever attorney it is, say, show me your evidence.
They don't need any evidence. Evidence is a waste of time. Okay. Evidence and facts is a total waste of time. All this, I hear a lot of these guys like a Mark Stevens screaming up and down about facts. Facts are irrelevant. Evidence is irrelevant. You want to know. You want to see that man. You want to see that man that's caused you harm. First, you want to see if there's even a man. Is like I said, Paul Gordon Hall went bananas on me because I was giving you guys the trick. Is there a claim that's been properly presented to court? Yes or no? As soon as you say that, only man can make a claim. And attorneys can't make a claim. The court can't hear any matter, see any evidence, see any facts, can't hear any witnesses, can't take any statements, don't care about statements of fact, don't care about anything in a file, any pictures, nothing. You got a proper claim filed before this court, yes or no? Now, all that other nonsense that you've been learning from all these other gurus, I just told you in one sentence, man. Everything else is done. That's all you have to say to the other side. I still have not yet to this date seen a proper claim filed before this court or any court. Please present me the claim that's been filed against me, my person, or my property. Thank you. And you're done. You just established everything. That's common law. That's it. There's facts, there's evidence. Do I have a code apply? It's all bull. Where's the claim that's been presented to the court? Has there been a claim properly filed before this court? I do not see yet at this time any proper claim. Please present your claim or cease and desist immediately. If you're going to try to move a false claim against me, be prepared that I'm now preparing a case against you for filing a false claim. It's simple. Like I said, but these gurus ain't going to make a damn freaking dime on me telling you this. The attorneys ain't going to make a damn freaking dime if you guys start to learn this nonsense that I'm saying. It's done. This is simple.
Does that entail verified declarations? Are those claims?
Is there a proper claim filed before this court or any other court within this territory, this jurisdiction, or in this universe? Let it come forth now. And I will answer the claim, and I'll compensate the harm. And whatever me, my person, my property has done to cause the harm, I'll compensate and tender, and I'll render all, I'll settle all debts, settle or discharge all debts at this time. Make the claim known. I'll hang around here for 10 more minutes, and I'm going to hell home. That's it. That's how simple court is. How much money can I make doing that? So go ahead, guys, and keep rattling your brains and studying this stuff and all you want. I don't really care. I'm telling you, it's this simple. If you don't believe me, go ahead and just keep researching, keep filing all kinds of crazy stuff. I don't care. That's why Gordon Hall went bananas on me. He said, hey, Carl, hey, you're showing the magic trick. You're showing how the rabbit came out of the hat. Don't do that, Carl. That's our bread and butter. Get this guy off the phone. He's a maniac. Yeah, that's right. It's like his buddy's like, well, Mr. Hall, that's a hell of a question. Why bother proceeding if there's no claim before the court? Get this maniac off my show.
Yeah, I enjoyed listening to that call, Carl, and I used to listen to Gordon a lot, but as soon as he belittled your trade of being a truck driver, I stopped. I couldn't handle it anymore. I didn't think he was. I didn't think he was like that, and it really made me sick. I mean, it just. There's no need for that.
What I could tell Gordon is while I was a trailer driver traveling across the country delivering fruits and vegetables and poultry to all the people of the United States and fresh fish from Cape Cod up there in that area, Cape Ann, Cape May, while I was doing that, you were sitting in jail because you ripped off a whole bunch of little old ladies on Ponzi schemes, from real estate closes that you never had. You're a real estate developer, but the FBI said in their Department of Justice report that you were a paper developer, that you never picked up a brick in your life. So while I was out there doing his honest pay for an honest day's work, you were sitting in federal prison, buddy.
Amen, brother. I hear you.
I could have said that to him, but I didn't.
I think you held your composure very well. He lost it.
Oh yeah, well, I don't really want to say bad things about people, but right. That's how I could have done it, but I chose not to. I don't feel there was any, I don't need to explain to him where his failings in life is. That's not for me to judge him. But that's how I felt, but I kept it in me.
Well, the other thing, Karl, is, when you go into court and you say, okay, is there a proper claim filed before this court? And if they go, yes, I go, where's the man, who I've done harm? Where is he? Oh, he's not here. His lawyer's here. Well, that's fine. It's like the guy's not there. You tell the lawyer to shut up and sit down because you go, I'm here to answer a claim. You say that there's a valid claim. I haven't seen it, but, this lawyer over here says there is one. But the guy who's prosecuting it isn't here. So guess what? I want this, I order this case to be discharged immediately without prejudice.
No.
Because it's never done this.
No, Greg, that's dishonorable. What you say is, Maybe the man was incapacitated because he's a castaway on Gilligan's Island. He couldn't make it here. Or maybe he's in a coma, or maybe he got into an accident. But at this time, I want this proceeding to stay these proceedings until a man comes forward. And I want the case to be dismissed without prejudice. I'll leave this book open. It's unwritten, and it's not signed yet. It's not sealed. The deed isn't done. I will let any man come forward and make a claim. I will make a claim because I want to settle all debts honorably. So until that man comes forward, the book will not be sealed. And like most people say, is 7 years or 10 years that the court will stay a proceeding until you close the case and say, well, the man hasn't appeared. I guess he's lost at sea. I guess he's died. I guess he's given up. Then you could come back in 7 years or 10 years, whatever acceptable within your district or territory, your land or your county, your province or your country, whatever you want to call you people, whatever you want to call your area in which you squat upon, whatever acceptable, 7 years, 10 years, 2 years, whatever. And then you say, you know what, I don't want this brought up ever again. I want the book sealed. I want the case closed. I want a discharge. I want the claim to come to me, and I want to, you accept all equity in that claim. So when you go there and then you say, I'm taking the claim. Release the claim to me. And now you take the claim, so it's forever. And then it's like you people see that Archie Bunker show that All in a Family where Archie burns his mortgage. Like, yeah, I finally paid it off. Right, he got rid of the claim. He got rid of any record that anybody could come forth ever and use this mortgage against him to try to obtain another dollar. You take the claim and you burn it. If you want to, you stick it on your mantle on your bookshelf somewhere. That you paid off a debt. You go back and take the claim. No, you don't.
I was trying to say basically that, Karl, okay, so it didn't come out right, that's fine, but the reason I was bringing it up was there are going to be some circumstances where you're going to go in there and do everything properly, and you're going to get a magistrate judge and his cohort lawyer that are going to just ignore you. They're going to say, no, we're just going to do this anyway. That's when you have to be able to be prepared with your or else.
Please explain, Greg, or else.
All right. In other words, if you say, is there a proper claim before this court, and they go, oh, no, well, there's a complaint over here that this guy has filed to this company. I said, is there a claim here before this court? And they say, well, there's this thing. I go, if there is no claim before this court, and there is no man that I've caused harm or injury, I move this proceeding be discharged. Now, if there's no claim, okay, in the previous scenario, Karl said, if there was a claim but the guy wasn't there, all right? Now, if there's no claim and there's just a complaint by, U.S. Bank or whoever, if there's no man to testify, to come over there and say that, we did him harm and it's just a complaint, you order the thing to be discharged with prejudice, okay, because there is no man. There is no claim. It's just a bunch of lawyer bullshit. Now, I apologize for cussing. The point is that they will sometimes try to just railroad the thing through, even though they know and you know that they've got nothing to go on. All right? And at that point in time, you need to say, if you, Bob Smith, judge over there, or lawyer over here, try to take this any further, you are going to be personally liable, acting outside the capacity of your office, and I'm going to sue you and hold you directly liable, and it's going to cost you this much, period. All right? That's when you nail it right there. And then if they go, blah, 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 you're threatening the judge, whatever, it's like, who cares? All right? And if they try to go proceeding with the thing anyway, you just say, I order this thing discharged and dismissed. Discharged or dismissed, with prejudice. If you can't, and that's all you can do. And if they go ahead and they make a judgment against you, in spite of the fact that you just protested that and said that there was no case to go against you, you can then use that judgment as the evidence for a wrongdoing against you, and you can sue them in common law for that, in addition to the original thing that they brought that had no claim. Okay?
Gotcha.
Well, that's what we do, Karl, when they just move ahead. And I just gave them terms and conditions for me to appear to fulfill their order to appear. And today they got my bill. And we'll see where it goes.
Did you send me your bill?
Not yet. Well, I did one. I didn't hear from you, and I had 2 or 3 other people review it. So It was in pretty good shape.
All right, yeah, if you want to just send it to me and I'll tell you what they might or might not do.
Okay, I'll be more than happy to. I identified the terms that off of the stipulation off of the terms and conditions to appear. I appeared when they asked me to appear. Now they have to compensate me. My compensation was $1 per second from the inception of the situation, which went back to January 22nd. Well, it added up to a nice little tidy sum. And then I put another stipulation in that if they didn't answer the terms and conditions, that the ancient maximum of times 4 would kick in. I got to quadruple the amount, and I noted it all in the front. So we'll see.
Okay.
I'll send it to you.
You're doing it a little bit, a lot different than I would have done it. But what I'm saying is they charge you with violations, misdemeanors, or felonies. What did they charge you with?
Misdemeanors.
Okay, misdemeanors they charged you with. Have those charges been settled, dismissed, discharged? You accept the equity?
Nope. Not yet.
Okay, folks. Like I said, I'll just do a simple one for you guys real quick here. The first thing you do before you demand compensation for the wrong, first you get rid of the wrong. You prove that beyond a shadow of a doubt that what these people did to you was wrong. You get that settled and you get it done. Then what you do is you go after the compensation.
Yeah. Okay, I did that in declarations, and I did that in the terms and conditions.
Honestly,
in a verified declaration.
Honestly, I really don't know what a declaration is, and I don't know what verification of claims is. I don't really know what any of these words are that you just used. But if you believe in these words, if you believe they have merits, can I write a book about those things you just said? Oh, absolutely. But do I know what they mean? No, absolutely not. Because to me,
you have to know what they mean? No.
It's just way too complicated. It's just way too much. I'm just making a claim. Now, did I cause, is the man who claims that I did wrong, is he going to appear? Yes or no? No. Okay. Well, then all these charges that you got against me, well, now I'm going to take these charges that you burdened me with. You placed those burden of those charges. You put the charges on me, right? You charged me with them, right? You placed the burden on me. Good. Now I'm going to accept all equity. All the value that you wanted, what these charges are worth, now I'm going to establish what the burden was. I declare that this burden of putting this charge on you is worth $500 a day. Now I'm going to charge you. You filed a false claim. You burdened me with a false charge. You placed a charge on me, like electrical charge, and I've been carrying around this thing for weeks now, months. Yeah, I accepted the charge. But now you have to prove your charge. I was a good guy to accept that charge. Now, you filed a false charge on me. I'm going to turn around, and I'm going to discharge it all over you. So like I said, you just go about it a different way. First, if somebody wants to place a charge on me, I was like, oh, lovely. You're going to hand me an order? Oh, good, lovely. That's how I make money. Oh, good, you're going to charge me? Oh, good. That's
what I did.
Charge on my debit card. Charge on my credit card. Charge on my debit card. I don't care. Charge on my gift card. Go ahead, charge it up. Get charged up. And if you can't prove it, you're going to pay the bill. I'm going to hand the bill to you. You're the one charging up this card. You charge up my credit card. You charge this. Oh, you want to charge up? Go ahead. Now what do you think I did? Oh, wonderful. You got to prove it. You got to prove that this charge is going to be true. Because when I find out, when I can prove that you bear a false witness and you file false, and all these charges are false charges, I'm going to place the burden on you, and I'm going to win in 2 seconds. So, like I said, I just make simple claims. If you want to make a claim, and you like I said, where's the claim? Is there a proper claim to file before this court? Yes. Is that what you claim as a claim? If you're trying to place that claim upon me, oh, lovely. I'll accept that claim. I'm going to show that the claim is false. And then when I prove that my claim is false, I'm going to charge you.
My whole issue was that they wanted me to come back in their room and appear again, and I asked them if it was their wish that they wanted me to take their order to come back and appear, and they said yes.
There you go.
And I said, oh, thank you very much. You have in your hand already my terms and conditions to appear.
Well, that's it. You could do that, but if they fail to ask, it's like I said, going to a fancy French restaurant, and they don't have no prices on it, and you just start.
I asked Carl.
Just saying. I'm just saying to people who are listening to this call, if you go to a fancy French restaurant, and there's no prices on the menu, there's no fee schedule, and you just go in there ordering somebody about, and telling them, give me French Champion, give me a bottle of Dom Perignon, give me this, and they come back with a bill for you for $20,000-$30,000. You're obligated to pay it.
Right.
So just because a judge orders you about, you say to the judge, is that your wish, Bob? Not judge. Is that your wish, Bob? Yeah, okay.
Yeah.
Bob, he's liable now to pay it. Did you have to present a fee schedule? Of course not. Did he ask? No. So guess what, Bob? You ordered me to do this. Guess what, Bob? Lovely. Wait until you see the freak. You don't say to him. You're saying in your mouth. But I'm sure for a woman, it's hard for you to put it in paper and writing. It's hard to keep quiet. You say, oh, lovely, lovely. Wait till he sees my bill. He's going to swallow a pickle.
I know. I didn't really say a whole lot other than you wish to take my terms and conditions. I mean, you wish me to come back, and they said yes. I said, oh, well, thank you very much. You already have in your hand my terms and conditions to come back.
Right. Well, see, that's what I'm saying. That's what I would not do. If you're playing poker, you keep your cards close to you, and you don't keep saying, look, well, you want me to come back? Look, I already got an ace, a king, a queen, and a jack. You know, maybe I have that 10. You know, you might get them a little nervous. I want them to think I'm a complete moron. I don't want to give them any fair warning that what's going to come from me. They're going to say, holy bananas, how the hell did this just happen? Who's the moron that let this guy through? So they get to lay your case for who knows how long. They could just, like look at poor Tom Murphy. How long has he been dealing with this stuff now? 3, 4, 5, 6, 7. How many trials he's been to? They're just waiting for him to make one little mistake so they could violate his probation. Everything that he did gets thrown out. He goes back to square one and spends his entire time in jail, and no more probation, no more parole, nobody. He did not accept bail, whatever. They keep going on and on forever. So to me, I'd rather say, is that your wish? Is that what you want to do? Good. You just keep doing what you're going to do, and just let them do what they're going to do. And then once you say, like I said, then you spring it on them. When you prove beyond a shadow of a doubt that they had a false claim the whole time, there was nobody thrown to you. There was nobody harmed by what I did. I already told you folks this was common law by just saying what? Bob, do you claim this? You know, Judge, what's the judge's name? Joe, do you claim this? You claim I broke the law? Prosecutor, Bob, you claim I did it? Oh, the officer's name is Sam? Sam, you claim I did this? Good. I got them all in common law because only man can make a claim. I said, you broke the law. I broke the law. Good. Now, Judge, you know the rules. You know law. Only man can make a claim. Where's the claim that's probably been submitted before this court? Did Sam, Bob, or Joe make a claim? No. Is there a claim before this court? No. And I'm going to get every single one liable. Every single one of you now are liable. You just committed perjury.
What I did was put most of that in my paper, Carl.
Right.
Rather than explaining it, I just put it all in the paper. I said, you default. This is what it will be. Well, they defaulted.
But all I'm trying to say is, instead of telling the man that you're going to charge him for every minute, every second, every day, let him just keep running it up. Why? He's not asking you. He knows the rules. Ignorance of the law is no excuse. If he orders another man to do something, he's bound to pay the bill. So, you know, you can't say, I order you to mow my lawn. Okay. You never bothered to tell me how much I was going to charge. You just told me to do it. What makes you think I can't demand compensation now after I did it? What do you think I was going to do it for free? What do you think you had jurisdiction over me? What do you think I could over me? Is that what you presumed? Is that what you, well, not only you presumed, now you assumed it because now you're going to be liable for damages. So like I said, but if you don't establish the fact that you're a man or you're a woman and that you have rights and that you could not be ordered about by some sort of fictional code or some code that's not applicable to you, and they decide to do it anyway, then you could hand them a bill. But if you don't establish the fact that you're a man or a woman and that I was not operating a motorized vehicle under Washington State Code 1234. You know, I was just a man just traveling from point A to point B, and I didn't hurt nobody when I was doing what I was doing. So unless somebody's going to claim on, you got to back off with your frivolous claim, or I'm going or you can say you better back off from moving with this frivolous claim against me. You don't have to say, "Oh, I'm going to demand compensation." You just say, "I demand that you back off from this frivolous claim." You don't have to say, "or else." Just say, "Demand it." If they don't, you really don't want them to back off because you want compensation. You say, "Well, I gave you fair warning. I told you back off. You know the rules. You don't back off. You don't cease and desist. Guess what? Here comes the demand for compensation now. How long have you been doing this to me? 3 years, 5 years, 11 years? God bless you. Because now when I get this before the jury is just going to eat you for lunch. Because I told you 10 years ago to stop, and you didn't stop. And when the jury says, well, why didn't you stop the first time she told you to stop? Well, you know, we just thought, well, I guess you thought wrong. And now you got to pay for all this time for messing with it.
Mm-hmm.
See, I just don't like to let too much out of the cat out of the bag. I just give them one sentence at a time. And I let them, hopefully, they just totally ignore me and say, this guy's writing gibberish. This doesn't even, this is like not even a complete sentence. This makes no sense. Okay, fine. That's fine. I don't care what you say. And I'm gonna move this before a trial by jury. And I'm gonna bring you in, Bob, Sam, and Joe. Not prosecutor, and not officer, not judge. You guys all know the rules. You all know the law. You knew what common law is. You're supposed to know it's the premier, the number one law of this land. You all know how this country operates. It says there right in the U.S. court website, all state courts are common law courts. You all know every place we're standing in this country, if I'm in some court of state, and every courts within that state are common law courts. And you could subdivide them from there. It's just like what I say to people, property. Everything I claim is proper to my person is my property, which means my rights, my children, my car, my spoon, my clothes, my dreams, my hopes. They're all subdivisions of or subsets of my rights. It's the same thing when you say all state courts are common law courts. They all start at the top of the pyramid as common law. Then they can break down to admiralty, maritime, any other kind of law you guys want to use. That's fine. They could flip their hats on and change courts, change the law at a flip of a hat if they want to. And even though you try to move onto common law, you folks try to sneak in some statutes every now and then and get you guys in trouble. So then it just took you down from the top of the pyramid down to a statute, or you used a precedent and it took you down to, or it took an act of Congress, 1802, and it dropped you down into that act. It took you from the top of the pyramid and you're slowly knocking yourselves down further and further and further. Or UCC and stuff. That's really dropping you down near the bottom. So like I said to you folks, man, is just make one simple, plain statement lines, but it's so hard for you guys to control yourselves because it seems like the more you write, you believe people are going to be impressed because, especially you, Maria Janet, you were a school teacher. If I wrote a paper, my paper would have been one sentence long. You would have given me a big fat F with a big old sad face on it. Some kid would have walked in with 10 pages, 500 words or more, like you told him to do, and he would have done it. And you would have given a big A+ and a happy face. But my paper said E equals MC squared. My name was Albert Einstein. But you know what? His teacher gave him an F- because he did it in, 5 or 6 letters or less. But she said she demanded 1,000 words or more to get the big happy goals. That's what they trained you people to believe, that more is impressive, that less is a joke.
Yeah. No, in my school, you had to work the apparatus. You had to show me you could do it.
Right, but E equals MC squared, I guarantee Albert Einstein's math teacher rolled up the ball and popped it off his head and gave him an F.
Oh, I'm sure they did.
Yeah, and said make it 10,000 pages or more, or we're going to flunk you out of school. Doesn't cut it for us.
I was such a different teacher.
Right.
I didn't do any.
What I'm saying, when you go to court, you write E equals MC squared and stop. And don't explain what E equals MC squared. It's none of their damn business. It's only between you and the jury and the other side. The guys in the black robe and the prosecuting attorney say it has nothing to do with them. It only has to do with the person that you're moving in court or they're moving you. They know what E equals MC squared is, because if they didn't know what E equals MC squared means, they wouldn't have been communicating with you. So, like I said, incredibly simple, one sentence. The other side know what they did wrong. It's like, Bob, pay me back $500 because you did me wrong. Now, if Bob's the prosecuting attorney or the sheriff or the guy in court or the judge, say, Bob, pay me $500. He knows what he did wrong. He moved in a capacity in which he wasn't permitted to do as a judge or as a cop or as a state prosecutor. If you want to say, well, Bob, pay me $500 because you did this, you want to write a freaking book about it, you're wasting your time. Bob knows what he did wrong to you. He knows exactly what he did wrong to you. Now, could Bob make a statement of facts or like a billing statement? Why you believe you should be paid $500 from Bob? A little bit of a story. A little bit. You don't have to. You can say, no, Bob, you know and I know what you did. You know what? I'll see you in front of the jury.
Yeah.
And there you go.
I think that's why they set my hearing outside of the speedy trial, so they could get rid of it.
They set it up as a speedy trial?
They set the next hearing outside of the speedy trial rules.
They could do that. What I would do if I was them, I would just I'd let the statute of limitations run out on the charges against you and just let it drop.
Well, I think that's what they're doing.
That's what they're going to do. They're going to let the 2 years of limit. Like Canada, it's 6 months, and the United States, it's usually 2 years for them to prosecute a wrong. And they're just going to say the judge couldn't make it. The judge had a death in the family, whatever. Because until you make your own case, all this stuff that you're filing in their case is going to be totally ignored.
Mm-hmm.
It's going to be totally ignored. They don't see it. You're just packing it in the sausage. It's just getting lost in the ingredients. They don't see it. You're just stinking up their case. And they're like, man, this lady's really stinking up our case, our sausage. She's making it stink. You know what? Just let it rot.
Still can't make a claim or answer my claim.
But you haven't filed your own case yet. You haven't filed a lawsuit against them yet. You haven't filed a case
Oh,
against them.
no, I need to do that.
Right, so everything that you're doing right now is good practice, which is fine. It's keeping your mind busy, learning a lot. That's fine. You're making a lot of mistakes. Good. Making mistakes in their case. That's fine. Because, it's not going to go anywhere. So, but at least you're learning. And you'll get better as time goes on.
Well, this will be the fourth time I will beat this charge that they tried to put on me.
Big deal. The charges ain't nothing. The charges, it's you want to get compensation.
Mm-hmm.
I want compensation.
You're right. That's right.
Right. So what I would do immediately, as soon as I know somebody charges me with something, I'm going to accept the charges and say, oh, lovely, this is how I get it. This is how I get paid. And now you're going to burden me with this. Oh, good. So now I'm going to show that your charges are false charges. So now I'm going to claim compensation due to your false charges. See, Mr. Gordon Hall used to do it a little bit different. Mr. Gordon Hall would tell you to accept the charges and plead guilty and settle it by paying, discharging the debt or setting it off or giving a $2 million side draft. Not me. Oh, you want me to accept those charges? Oh, yeah, I'll accept those charges, all right, but you better be dead on. Because when I can prove that those are false charges, I'm going to say, well, you burdened me with those charges. That wasn't easy and that wasn't a light burden to carry. Guess what? I'm going to demand compensation for you placing a false charge on me. You burdened me with something that was false. I knew from day one it was false, but you know what? I'm not going to make any money by not accepting the charges. So you know what? I'll accept that order, Judge. Is that what you wanted me to do? Good, lovely. And then I'm going to show that he placed a burden on me that I should not have been placed, that burden. He placed the order. He made the order for 10,000 Happy Meals. He's going to pay it. He made the order. He's going to pay for it. And there you go. Like I said to you guys, I looked at the federal court site, and all these judges and all the people within the court system, they all are insured, and they're all recommended to carry their own private insurance when they interfere with constitutional, statutory, or civil rights of the people that come before them. Because they will be sued one day in their personal capacity, and they will have to pay out of their own pockets. They got it right off the federal court website. How they should go about if they don't believe they're carrying the United States covers them under their insurance company, that they should go out if they have millionaire judges or billionaire judges, that they should go out and obtain their own private insurance in case that they don't believe they're going to be compensated or covered, indemnified under the government's policy. So it's simple. They all know what they're doing. They're not stupid people. They all know what's going on.